you, Jenny. That was some very good information. So if anybody has questions, go ahead and put it there on the chat. We wanted to welcome you here to our family law community of practice. And what we wanted to do was talk about and go take a deeper dive and answer some of your questions that we weren't able to address during the webinar. And so what we did was I grabbed some of the questions that we were able to get from the chat, some questions that people had sent privately off list, and we gathered them here. And we're also able to answer your questions live. I'm going to go ahead and turn the screen, and I'll let Leslie go ahead and say hello. And I'm Rocio Molina, Deputy Director from the National Immigrant Women's Advocacy Project. And I'll let Leslie and Veronica say hello. And then Leslie, please do introduce Edna as well.
Wonderful. Welcome, everyone. I'm Leslie Orloff. I direct new app at American University. We're happy to have you here. Welcome back to those of you that are part of our regular family community of practice. And wanted to welcome those of you that might be joining us in this forum for the first time. I'm going to turn it over for a second to Veronica Thronson to introduce herself, followed by Edna Yang, who's joined us as faculty today. Veronica?
Thank you. Hi, everyone. My name is Veronica Thronson, and I teach at the Michigan State University College of Law, where I direct the Immigration Law Clinic. And welcome.
Edna?
Hi, everyone. My name is Edna Yang. I'm the co-executive director of American Gateways. We are a nonprofit organization that provides immigration, advocacy, and legal services in Central Texas. I'm based in Austin, Texas.
So we are today, before we get started, want to tell you about for the family lawyers among you, those of you that may be joining us for the first time, we have a monthly meeting of family law community of practice. This is an example of some of the things that we do, covering a variety of topics. Rocio, can you put the slide up for the next one? It's 2 slides forward. Yeah, and OVW has supported this effort, and we often include slides that cover multiple different kinds of topics, and substantive material. But today we're going to be really just focusing on questions. Next slide, please.
This is for you folks that are members of the community of practice, so you can save the date. If you're a family law lawyer and would like to join our group, feel free to email me. I'll go ahead and share my email here on the chat in a second, but the next scheduled meeting is December 14th from 1 to 2 p.m. and I look forward to seeing you then too.
And the other thing you should know is for those of you with us today who may be victim advocates, we also have a victim advocates community of practice that if you're interested in joining, you can send an email to, does it go to you, Rocio? Or yeah, to Rocio, and she'll put her email in the box. And those of you that are family lawyers that might want to join us for future family law community practice, join that group. You can email Rocio as well.
So the materials for this webinar, I know a lot of the questions were surrounding the PowerPoint, the slides that we used, and supplementary materials. It's ready there for you to access. And so I wanted just to refer you back to that training page, and that's new app library.wcl.american.edu BSW for battered spouse waiver, training and materials. I'll also share that with you in the chat box. So let's get started on some of these questions. Starting with the first, the survivor you're working with has a 2-year green card. The opposing party is seeking a quick divorce. The party's married in 2020. Should you be considering delay strategies? Why or why not? We can open that up for the chat if you guys want to chime in on that. And then Veronica and Leslie start discussing that, or we'll wait to see what the group thinks first.
Are we going to have people join by speaking as well, or just on the chat?
think we can do both. We're a good size of a group where wouldn't be overwhelming. So we can give it a try. And if you want to unmute yourself and answer the question of what you think, if you would try to do delay strategies or.
In the family law case, you mean, right? In the divorce case. So anybody want to share some thoughts? Chat back on.
Okay, so somebody on the call says it depends on the bona fides and evidence of abuse, whether they would try delay strategies.
And Veronica, what might be the pros and why might somebody think of delaying or not delaying? What do you think the concern is here?
So one of the things that I was thinking, and as I saw this question, was like talking to the survivor, right? Like what is her situation right now? Is she able to have a place that is safe where she can live? And does she really want to go forward with the divorce, right? Like we really don't know exactly if he is the one who filed and his reason for filing. Right, if there has been abuse and she has, as someone said, if she has enough evidence, right, like what would be the strategy for her to try to delay it? And one of the things is that if she has a good advocate who may be telling her immigration options, that's one thing. Many times people think that they need to continue to be married to the abuser in order to remove the condition on the green card, which is what I assume is happening here with this fact pattern, right? That she has a conditional green card, and she may be thinking that she has to have the husband sign the joint petition to remove the condition. But as we learned from the webinar, she really doesn't need to have him jointly petition to remove the condition if she has evidence of abuse, and then she can do the battered spouse waiver. So it would be a matter of what is the strategy with the client, right? Like what is it that she wants to do? Does she know that she have immigration options that don't require him to join with signing the petition? Right, so I would absolutely have that conversation with her, telling her there is no need to delay it if you are able to show that during the marriage you were abused and that you really don't need him to join in for the petition, which is something he may not know, right? Like he may be asking for a quick divorce so he can actually get rid of her, and he's thinking, I'm going to screw with her immigration case, right? Like she's going to get deported if I don't sign it. And that's the reason why he's trying to get a quick divorce.
Right, and exactly. And so for me, one of the other things I'd be thinking about is that's an indication. He's trying to get a quick divorce because he thinks that divorce is going to cut her off from immigration status. And for this group of people, if she's gotten her conditional green card through him, it won't, as we learned in the webinar, but in other types of cases, it might. And so the other thing is I would really want to do a thorough interview of my client if this was the way she presented the facts to me, because this is evidence of immigration-related abuse. And immigration-related abuse is closely tied to physical and sexual violence. And so when you look at the social science research, so to me, that's a red flag that I need to be sure that I'm digging further into this case as I work with my client to get all the evidence out about the physical and emotional and psychological and sexual abuse, because this is a case where that is likely to be there. But in terms of, as Veronica said, from an immigration perspective, because she's got a 2-year green card, a conditional green card, he filed for her. If she's got good evidence of abuse that you can develop, then she can proceed with the battered spouse waiver, or divorce. Still, either way could work. But as we'll be talking about, as we talked about the webinar, the battered spouse waiver is usually the best option in terms of what future options she has and what it opens up for her.
Edna, do you have anything to add with this fact pattern?
No, I mean, I think you all covered it. I think if the fear is that it sounds like that folks are worried that the divorce is going to affect the immigration status, and the battered spouse waiver really does protect against that. And then, you know, you can always check more than one box on the waiver form as well too. So you could say that it is a no fault, good faith marriage first, and then also the battered spouse waiver box as well too, to kind of cover all of your bases if the divorce does happen quickly and you want to have more than one reason for that waiver.
If you're wondering how you know if your client is a conditional permanent resident, here I use the term 2-year green card, and in the next slide I'm going to use conditional permanent resident. But if the green card is valid for 2 years, that would be your flag to know that it's a conditional resident, or the code on the card if it says CR. That's how you would identify if they were conditional residents, because sometimes they won't know themselves that they are conditional residents. So let's go to the next question. You learned that your family law client is a conditional resident. What are some things you should start considering, and what are some things that you can automatically assume? Or you all that joined the call, and I know that while we were in the webinar, there were a lot of you that were experts on this and had some familiarity with the battered spouse waiver. You guys want to give it a shot in the chat or unmute? What is that, something that you need to already start to plan for, or what are some facts that you automatically know when you know that they're a conditional resident?
Why might that piece of information be really good news for a family lawyer? Trying to make it a little easier. Veronica and Edna, what does it mean that what will there be in this case that there might not be in other cases that the family lawyer should be aware of?
I mean, there's an affidavit of support, so you could try and enforce that. You have an idea of assets, especially because I think in a lot of the cases that we've seen, abusive spouses have tried to hide assets. And you know, if you have the immigration documentation, then you can have you can through discovery get that information and have be in a better position in terms of property and assets in general.
And Veronica, can you maybe just for the people that, could you remind us some more about what kind of evidence, what kinds of things you might be able to get through discovery if they filed an affidavit of support?
Sure. So for the affidavit of support, the petitioner, in this case, we are going to assume that she has her conditional green card based on marriage to this person. So he must have submitted evidence of his taxes, right? Because he needs to show the government that he is able to support his spouse at 125% of the poverty guidelines. And the government requires the tax records for the last 3 years. They require proof of income. They require proof of employment, any other optional assets that he may have submitted to show that he was able to support her. And so that's actually very good evidence. In most of the cases, people don't have a copy of the affidavit of support, but you are able to get that through discovery in the family court proceeding.
So this is one of the ways where the battered spouse waiver, or the situation where the husband actually filed papers for and she got a conditional green card based on those papers, then that, you know, that affidavit of support is it's active. It's not just a piece of paper. It actually is a valid contract because her green card was issued as a result of it. So no matter, even though she's going to do a battered spouse waiver or something like that, or even though they divorce going forward, that's something that we as family lawyers want to be sure that we don't forget about, and that we actually try to get it enforced as part of the divorce proceeding, because it can be a really good source of income for some of our clients. And Veronica, when does it end? Like if they divorce And does it end the affidavit?
Well, the good thing is that it is an enforceable contract, and divorce doesn't kill it, right? So there are only certain instances in which he could claim that he's no longer liable under the Affidavit of Support, and divorce is not one of them. So because she is a conditional green card holder, we are going to assume that she doesn't really have 40 qualifying quarters of work, which would be about 10 years of work. She's obviously not a US citizen, although she could actually apply after 3 years, depending on the battered spouse waiver. She's still in the United States, right? So she hasn't left. And and she's alive, right? Like neither the sponsor or the immigrant are dead. And so those are the only times in which you are able to get rid of the enforceability of the Affidavit of Support.
But there's some case law, I think, that says that in some places it's a good red flag, which is why I'm glad somebody asked this question, because you want to litigate it in the divorce case if you can, because you don't want the abuser to come by and say, what is it that you gave up, you know, you missed your chance, basically. What is it? There's some case law that
like claim preclusion, right? Like when you could have brought it up in the divorce and then you didn't do it, right? Like, and then later on you want to bring a civil action, he could claim you had a chance to bring this Affidavit of Support during the divorce claims and you didn't, and so you missed out.
Right, and there's some case law that says that, not all jurisdictions, but it's something to be aware of. And so good practice would be, as the family lawyer, to include it routinely as part of your family court case when your divorce case, you know, when you're representing conditional resident. Should go to the next slide, Ro.
Sure. And, you know, as we cover these questions and another question comes up to you, please send it to me here on the chat because we are going to have a little time up for questions and sometimes they're relevant. So, and I won't hold them off and it might be better to answer them as we go along. So feel free to do that. The next one was, there were a lot of questions on the chat about certain pieces of evidence. You guys asked if you needed police reports, if you needed protection orders. There was another question where somebody had, instead of a police report, they had an incident report and that USCIS was asking for the police report. And we also talked a lot about which kind of therapy records were better. Was it from a licensed psychologist or medical evaluation? And so from that, we wanted to share with you, I know that in VAWA, a case cannot be denied for failing a particular piece of evidence. And it can only be denied on evidentiary grounds if the evidence that's submitted is not credible or otherwise fails to establish eligibility. And so my question was to Leslie and Anna Veronica, does this also apply to battered spouse waiver?
So if I may take that, I'll start with that. So first of all, what's really interesting is that the any credible evidence rules that apply to VAWA self-petitions were designed, we negotiated them and wrote them for battered spouse waiver cases. Because this is one of those areas of immigration law where the regulations that if you look them up today, the regulations you will find will tell you that you need this licensed psychologist and all this stuff. Those are regulations that were written prior to VAWA, prior to 1994 VAWA and 1994 the statute. We wrote the any credible evidence rules to explicitly overrule those regulations requirements. And they are legally null and void. The part of the regulations for battered spouse waiver that says you're supposed to go get a psychologist's evaluation, et cetera, are null and void. They were overruled by statute in 1994. But the DHS has not updated the regulations. And so that creates part of the confusion. And in fact, so when I was involved in training the Vermont Service Center staff, the VAWA unit, one of the things that became really clear is they prefer, the experts at the VAWA unit prefer affidavits from the shelter provider, from a treatment professional that's actually seeing the victim, not that they go to get an evaluation for the purpose of the immigration case. And those can be helpful, but they're not mandatory. And that there is no single piece of evidence that can be mandated in either a VAWA self-petition or a battered spouse waiver case or a T visa or a U visa or any case covered by VAWA, because the VAWA confidentiality rules apply equally to all of those cases. Let me see, what else was I saw something flash across my screen and I got confused. Yeah, so that but the issue that comes up, and we talked about this in the webinar, is unfortunately the adjudicators who are adjudicating the battered spouse waiver cases are scattered all over the country at different service centers and different regional centers. They have a fraction, if any, of the training on domestic violence dynamics that the Vermont Service Center do. And so they're often asking, even though in the materials that we have for you on the thing, you have the FOIA request that says they cannot require any particular piece of evidence, they're still doing it. And so that's part of the problem. And so Edna and Veronica, what are your suggestions about how to reply if somebody gets a request for further evidence for these kinds of documentation?
I'll start it, and you can follow. One of the things that is important to remember is that people think that they just get denied, right? And CIS gives you a lot of opportunity to submit evidence. Many times, though, the evidence that they are requesting is something that you already submitted with the initial filing, and so it's quite frustrating. But it is important to respond, obviously, right? And so your client would have enough opportunity to respond to these requests, and many times that is what involves, right? Like you are asking for information that we already submitted, or you are asking for information that is not relevant to this case, right? Like, I don't know, between the incident report and a police report, I have submitted voluntary statements that my clients have gone to provide at the police, and it's not really a police report, and I haven't gotten any requests for evidence on that type of information that I submit. I don't know, Edna, if your experience has been different.
No, it's been the same. There hasn't been a difference between like a police report and an incident report. And here in Texas, if there's an ongoing investigation, or if they only decide to redact and release like a public portion, it's very redacted, or it doesn't have very much information. And we have actually submitted that as well. And I echo everything Veronica says. I think sometimes they're asking for information that you've already submitted, which is very frustrating. So I think there's two pieces of advice that I would say is, one, first, indexing is very important, and kind of just laying it out very clearly. This is what I already supported. Here are the pages and the tabs of what you are asking for that has already been submitted to you. Or if they're asking for primary evidence and it's very clear that it doesn't exist for whatever reason, or that your client can't get a hold of it, the important thing about any credible evidence standard is to state why the primary evidence doesn't exist and what you have done to try and obtain it, or why you can't obtain it. So, right, it may be that you can obtain it because some of that information, some of that direct evidence was destroyed by the abuser. So if that was referenced in like the statement by the client, repeating that again and saying, you know, this any credible evidence standard. And so here's the secondary evidence, including the affidavit, which clearly details how this information was destroyed. Or if there is no police report, because oftentimes there's not, then an explanation of why there's not, and the dynamics of domestic violence, family violence, abuse, and then explaining that, and then any credible evidence standard, I find has also been very helpful. I think training is an issue. I also think that like the adjudicators have a lot of stuff that they're looking at. And so it's easy to miss things. And so the clearer that you can make it for them about what the standard is, how you have met it, what the primary evidence is, why it's not obtainable, and why you don't need to do it because you've submitted the secondary evidence, which is just as strong, makes your case much more, makes it much stronger. And then hopefully we'll respond to that RFE in a way that will have them grant the case.
And then I have a question, Edna, for you on that. I think I like your approach because you're saying, here's what I tried to do to get what you asked for, and I'm providing this instead, which meets my burden of proof. But I think it's probably also a good idea just to put one line in there to say that you recognize that this whole concept of primary and secondary evidence doesn't apply in these cases. So although any credible evidence rules don't say that I can't be required to provide primary or secondary, I can provide whatever evidence I want, I'm still going to tell you this is what I did to get the primary and here's what I'm doing instead,
Right.
Just to kind of cover yourself, I think,
Right.
to say, so that you're not conceding to them that this primary secondary thing they're putting you through is actually what they should be doing in these cases.
Yeah.
Right. And I agree with that.
I agree.
But the reason that we do that is to make it super clear to them. Because sometimes when you just say, I don't need to do that, then
Right.
it triggers a little something in the officer where they're like, yes, you do. So in order to kind of cut that off and say, like, this is what the law says, but this is what I'm telling you in terms of why these things don't exist and what we've done and why you should accept these other things, it makes it just smoother for your case in general. And then they can kind of follow along. I also think it helps, especially with when you're doing that. I have found it helps in kind of reiterating the trauma and abuse that your client has gone through, right? Where you're like, look, if this was just like a normal family-based case, of course these things would exist. But because of the abuse and the dynamics of abuse, this is why all of this doesn't exist. And it kind of compounds that and reiterates that for the officer.
Absolutely. Yeah.
So there's
related to that, yeah, go ahead. Yeah, I'll go ahead and get it.
So there's a question that you're doing it, you go ahead. Okay.
So we have a Narad asking, in absence of police report, does it require a letter from an expert on culture why the police was not called, having to do with power and control, et cetera, or the counselor letter is enough as evidence of abuse?
Well, there is no requirement that you have a police report. It would be important to highlight why, right? Like the reason why I didn't call the police is, right? Like, and so I'm just thinking, I'm Guatemalan and I'm thinking, I don't know that my clients from Guatemala will call the police, right? Like they know that they get bribes or that they are in fact abusers themselves. And so that is not going to be the first thing my client is going to do. But if my client is getting counseling, a letter from the counselor is actually important, right? Like just saying I had been seeing her, in group therapy every couple of weeks, or, we discuss issues of domestic violence. Our organization only meets with clients who are victims of domestic abuse, right? So you have that information. But explaining it in the personal declaration, like why is it that they didn't call the police is important, right? Like the experience they have had back in home country is important. So the officer understands why that police report wasn't made.
And many times you'll have people who called the police and they didn't show up with interpreters. And so they ended up talking to the abuser. And if that happened once, then in the future, she's not going to call them again. And there aren't going to be any police reports because they relied on the abuser when they showed up. And we know that in like 10% of these cases, an immigrant victim will call for help for police and they'll show up and they won't speak to her and they won't take a police report, which is supposed to be unheard of, but it's unfortunately not. So yeah, and that the counselor, any person who's a professional, a therapist, a teacher, a doctor, a lawyer, anybody, that she has a relationship with that's not part of the case, that knows her, can talk about, an affidavit from that person can be helpful in these cases to help prove the abuse in addition to her own affidavit. It's not, required that you have these other affidavits, but it can be helpful.
So, in summary, the police report is not required. Those other things are helpful, but again, those are not required, correct?
Correct. I mean, you're required to prove each element of your case with whatever evidence you can muster that is, the best evidence you can put together for your client. Now, that's one of the reasons we referred to, and I think it's in the materials, is the trauma-informed interview tool, which will help you gather stronger evidence of abuse. And the stronger the evidence of abuse is, you can actually make a very strong case of the abuse based on your client's affidavit alone, when you're using those kinds of tools. So, but it's, and that these any credible evidence rules preclude them from saying you must have her affidavit plus. The affidavit alone can be sufficient, although if you have access to other evidence, it's always good to include it.
Well, I mean, if anyone has any other evidentiary questions, this would be a good place to ask them, because we did have several of them, but I think with the way you just explained that, Leslie, it clarified that for me. But feel free as they come along to type them in the box. And then here we're going to move on to a question on getting copy of the file, more towards VAWA confidentiality. But can the opposing party get a copy of the immigration application to remove conditions through a family court discovery?
So the answer to that is no. The answer to that is if she files a battered spouse waiver, no. Because the battered spouse waiver application has what's called VAWA confidentiality protections, and the file and the information contained in the file, the existence of the file, isn't discoverable and can't be released by the Department of Homeland Security. And there's very, very good case law on this. In U visa cases, essentially where people are landing is that the U visa certification itself might be discoverable, not guaranteed, but if anything's discoverable, the cert is discoverable. But that's a case in which you have a law enforcement official or a prosecutor or a judge who signed a certification that is part of the defendant's case in a criminal case. Or it's part of the EEOC's case in an employment-based case because the EEOC signed. But in VAWA cases, in VAWA self-petition cases, battered spouse waiver cases, nobody's had to sign, no government official has had to sign anything for this victim. So there's nothing in the battered spouse waiver case that would be discoverable under VAWA confidentiality rules. Even if the victim admitted in court or made it part of her case that she had to get a battered spouse waiver, he still can't get the file or what's contained in it. However, if she doesn't raise the abuse issues and files for divorce, so what's interesting about that is if she files for VAWA confidentiality, if files for battered spouse waiver, any case that she has anything to do with going forward, let's say her naturalization application, or maybe he got her arrested and she's got some other immigration case that comes up in the future. Everything has VAWA confidentiality protection because of that battered spouse waiver. Anything that has to do with her. If she files a divorce, files based on divorce, future cases that happen her future cases have nothing to do with the abuse. She's never had a case filed with the abuse, and that protection doesn't attach to her future cases. Are there implications of that, Veronica? Go ahead.
Well, I was going to say, but it doesn't mean that she has to provide it, right? Like I would object on relevance. Like, how is this relevant to the divorce? Like the immigration status of my client is not relevant. We are fighting over custody or assets here, right? Like how is, and he should know, right? Like if she got the green card based on marriage to him and her green card is conditional, and it's not of his business if she files based on divorce or based on, of course, based on the abuse, you have the VAWA confidentiality, but I would still object to providing it because it's not really relevant to the matter at hand.
And I think that's right for the divorce case, but for future cases, there may be, you can always argue relevance, but you're on much stronger ground if you can argue VAWA confidentiality in addition to relevance. Is there anything else, Edna, you'd want to add to that in terms of anything about what kind of future cases might it? Because the other thing that it does is if she's got a VAWA confidentiality case, it's not only her case that's in the system, it's the fact that because she's in the system flagged as a victim, if he tries to harm her in some way in the future through DHS, they can't rely on perpetrator provided information. So what I'm trying to figure out is if she's a recipient, if she gets her green card through a waiver of some sort, either divorce or battered spouse waiver, but let's say divorce, is there some future, like people with green cards could lose their green card in the future, right? Some way?
I mean, based on like what you're talking about, Leslie, I think it's very rare because those are rescission cases where they're going to say there was some sort of fraud, right, about the green card in the first place, especially if an abuser is alleging something, right? I also think that those are going to be somewhat more rare because it implicates the actual abuser themselves in some sort of marriage fraud, which they might not want, but who knows, right? What people do, but those are more rescission cases, I think.
But I was thinking about what if she ended up with some kind of a criminal case against her that he triggered, and that green card holders can lose their green cards because of criminal behavior, right? Criminal conviction.
But those are based on the actual conviction. So any type of like ground of removability that's based on a conviction, what you have to do is attack the underlying conviction in criminal court and say that it was by abuse. Because in immigration court, they're not going to look at actually what happened. They're going to look at the statute she was convicted under and whether it actually triggers a ground of removability based on just the wording of the statute that she was convicted under. And that's it. And so those actions don't count. It's more than, I think, if you have a client that has criminal issues, getting a good immigration attorney who understands that, who may be able to advise that criminal attorney to try and get something dismissed or pled out to something different based on the abusive conduct instead.
Okay, great. Just always wondering about that.
So there's a question on the chat if the receipt on the I-751 shows the basis for removal of the condition, and it doesn't. It's just, just the receipt of the joint petition you filed, right? It doesn't say if you filed jointly or if you did it based on a waiver. It's just a piece of paper basically acknowledging that you paid and that they are extending your green card while your case is being processed.
So how would you show that they filed under battered spouse waiver?
To whom?
Well, if you're trying to get the VAWA confidentiality to kick in the family court or...
So what I would just argue is if they're trying to discover it, I would say it's barred by VAWA confidentiality. You don't have to admit or deny that the case exists. You can just say, assuming it exists, I'm not conceding it exists, but if she did file a battered spouse, it's not discoverable. So people have done that. We've done it. I've done it both ways, where you admit that it exists and she got her papers through it, and then he can't get it, or you don't even have to admit that it exists. It's not discoverable whether or not she filed it that way. You just wouldn't, I think, ethically be able to make the argument if she filed based on divorce.
So another question, and here it is, I guess, of getting supplementary evidence to show battery or extreme cruelty. During a protection order hearing, judges like to encourage attorneys to talk with respondents to make them consent to orders, which means no findings. What do you suggest we do in these types of cases?
Rocio, is the issue about the, not having evidence for the battered spouse waiver case or the VAWA case? Is that what the question is about?
Correct. I think, in this part of the webinar, we were talking about how protection order findings and all kinds of evidence that can be helpful to show battery and extreme cruelty. And so one of the challenges that they were sharing with us was that during protection order hearings, they were getting a lot of no finding protection orders because respondents are consenting, because the judges are encouraging that.
So I can jump in because I've actually had several of these for like VAWA cases and for battered spouse waivers. And it hasn't actually made a difference in our cases because what we kind of argue is that the existence of a protection order, even without the findings, right? We say this is the reason there aren't findings. So I'll have the client talk about it in her affidavit. Like, I just wanted protection more than anything else. So I wanted to ensure that I get this order. And this was one of the reasons that the attorney told me that we should go ahead and accept this. And I haven't had as much, I haven't really had any RFEs or anything based upon that. I will also say though, a lot of those cases, I have had some police reports as well too. Sorry, did someone want to jump in?
No, I think we're fine.
Okay. So, I mean, I don't know, Veronica, if your experience has been different, but I have had a number of cases with protective orders without those findings. But the existence of the protective order is something that we argue is a finding in and of itself. And that really the reason that we agreed to all of this without the findings is because the client just wanted protection because they were so afraid. And then there's all of the other evidence about the abuse that we put on as well.
Yeah, and it's basically, you know, the judge is going to be issuing the order of protection, right? And so basically, if the respondent is agreeing that the order, that he's basically not contesting that the fact that, you know, they may be agreeing like, we'll issue the order of protection. And I have never gotten any request for evidence asking me, but what were the specific findings, right? Like, here's the order of protection. It was extended for a year or, you know, 3 years, right? And that's the evidence you have.
Right, and as I just want to address what Susan Pearlstein put in the chat as part of this discussion too, and that is that, and to say that I'm assuming, Edna and Veronica, that when you submit that protection order, you're submitting the affidavit that went along with it too. So they can see the abuse you were complaining about and the protection order you got. And then
I always submit the petition that brought me to this point where the judge is going to issue the order of protection. Yeah.
And then I think Susan's point is a good one, that she's saying she would always get the protection order however she can, because I too, Susan, have tried to get judges to like do a hearing because you want findings. And if the defendant is willing to agree and the judge won't, you don't want to anger the judge and make them go through a hula hoop they don't need to. And so what the good news here is that these consent orders where they're not making specific findings will work for the battered spouse waiver cases and for the VAWA cases. And so from an immigration perspective, there's no need to have the family lawyers change what they're doing. And the only caveat I would add to that, I always jump when I hear no findings orders, because I think of something different than what we're talking about here. There are some instances in which, as part of the consent, counsel for the abuser will convince the judge to literally cross out the part of the standard order that says, I have jurisdiction under this section of the statute to issue this order. And then issue an order where they specifically say they're not making any findings and they're just saying, stay away from her and do this and that. Those orders are those kind of orders where they're amending the form. There's two reasons they do those. One is they're trying to get around the laws that take the guns away from the perpetrators. And two, they're trying to screw with the validity of this in their immigration case. From my experience in terms of RFCs, I don't know that those orders would necessarily be more they could cause problems in the immigration case, but they cause big problems in terms of the perpetrator being able to keep his guns. So we did a whole chapter on this for OVW early on this issue, because you can't agree. The order's not valid. If he crosses it out and the judge isn't making a finding that they have a jurisdiction and they're issuing this thing by consent, you can issue an order where the parties agree under family law based on the uncontested affidavit of the victim in a civil case. That's how they get there. That's how they get legitimate jurisdiction to do consent orders. But if they're starting to try to modify them in ways where they're arguable that there's been no finding that the court has jurisdiction here, which the judge gets jurisdiction on the uncontested affidavit of the victim, then you have problems later on if he violates the order, where there have been cases out of Texas. Laura Martinez ran into one of these years ago, where you couldn't, he was saying in the enforcement case that you couldn't hold him accountable for violating the order because it wasn't a valid order, because his counsel got the judge to cross out this part of the order. So it's just something to be aware of. We've got tons of materials on it if you run into it. If what we mean by no findings is they're making no specific findings and they're just filling out the order by consent and not altering the form in any bizarre way, it's totally fine.
Yeah, Leslie, but the restrictions for the order of protection with the gun, it has to be an order that was issued after a hearing in which he, let's say the defendant or respondent, had actual notice and had an opportunity to participate. And the order is to prevent him from harassing and stalking or threatening the abused victim, right? And so you have to have those issues before they can take your guns away. So in a case in which the judge is not having a hearing, and he's just ordering the order of protection to go forward, then the gun restriction wouldn't apply because there wasn't a hearing, even though he had actual notice.
Okay. Thanks for the correction.
Okay, well, the next question, we're going to be looking at a more technical question about somebody in, that could be in immigration or removal deportation proceedings. And so could a person apply for the battered spouse waiver if they were already in removal proceedings? And then second part of that, would it be helpful to show they're eligible when requesting deferred prosecution, prosecutional discretion, or administrative closure? Edna, Veronica, go ahead. I'll let Edna go ahead, start us off on this one.
Yeah, so generally, if someone gets put into removal proceedings, I'm assuming this scenario is that someone has already had their conditional residency lapse, and then something happens, they get picked up, they're seen as technically out of status, and they get put in removal proceedings. So the jurisdiction for the joint, for the I-751 to remove the conditions is generally with USCIS first. So I think you would have to apply to USCIS and use one of the exceptions. So either a no faith or good faith, no fault, which is the divorce waiver, or the battered spouse waiver, and state why you're not filing jointly within the 90 days, which is what you're required to do, right? And so once that's pending, then you could go back to the trial attorneys, the OCC, OPLA, and let them know and the judge know and ask for prosecutorial discretion. You could, they've been granting prosecutorial discretion in a lot of our cases, and you can ask for a termination of proceedings and argue, look, if the waiver gets denied, they're going to end up before you anyway, because USCIS may repaper them, and you can have them back in proceedings here. Or, you know, so that's like kind of the thing you could do. You could ask for administrative closure, or at minimum, you could ask for a continuance. If you have a trial attorney who is particularly litigious and won't do your prosecutorial discretion request, or you have a judge who says, I don't really care what you have pending with USCIS, what is your relief before us? The other option then at that point, I think, is you could also apply for VAWA cancellation because they're out of status. And you could say, like, you know, they have the 3 years, there's abuse, they're married to a US citizen, and do that concurrently. I don't think that that is really the favorite, because that's a lot more work. You're going to have to do both concurrently, I think, because I think you would still have to file the battered spouse waiver at the same time, just to kind of cover all your bases. I think it would be very rare that you do that VAWA cancellation case, because I think just nowadays, especially with the prosecutorial discretion memo, a lot, and with the fact that there are so many delays right now in cases, you wouldn't have an issue with that. You probably wouldn't even move forward with the cancellation case within like a year or two because of all the backlogs. So Veronica, do you have any other thoughts?
No, that's actually exactly what I was going to say. The VAWA cancellation is important to have in the, but you know, even Detroit, which is pretty strict, they have been very good at allowing administrative closure and even dismissal of proceedings when they know that our clients have something pending with CIS.
Great. And so now let's look at how that affects citizenship. How does applying for removal of conditions through using the battered spouse waiver affect the application of U.S. citizenship? So we know that VAWA self-petitioners can apply for U.S. citizenship after how many years? 3, you know, a lawful permanent resident. And so when can battered spouse waiver applicants apply for U.S. citizenship?
So it's 3 years as well? I mean, so the standard rule is 5 years. In VAWA 2000, we wrote a provision that basically gave VAWA self-petitioners and battered spouse waiver victims together. Well, actually we wrote it more broadly, but it got narrowed by DHS's interpretation of it. But DHS's interpretation of it for this purpose is that the idea was if you're battered, you should be able to divorce or separate from your husband, and you shouldn't have to remain with them or face waiting 5 years to citizenship. So battered spouse waiver applicants and VAWA self-petitioners, according to DHS's interpretation of the statute, both are able to file for citizenship after 3 years in green card status.
And that also includes the 3 years is also your time as a conditional resident. So if it takes a long time for your waiver to be adjudicated, they backdate it to when you first got your conditional residency. So I've actually had cases where right after we got the waiver granted, we filed immediately for naturalization because they had like 4 years at that point or 3.5 years. So.
Yeah.
And remember that once she's a U.S. citizen, she's no longer able to go after him for the affidavit of support. So if she's receiving any support and she's not in a hurry to become a U.S. citizen, she may as well wait to continue to receive that money from him under the affidavit.
Right. Or can you collect it back? I mean, like in the first instance, when you enforce it, if there have been like 2 years where he didn't pay, can you get those 2 years and then decide what you need to do going forward?
Yes, she is able to apply retroactively as long as they weren't living together, right? Because you are assuming if they were together, they were sharing their assets and there was no need for support.
So that's something to think about. If there's an affidavit, because there's an affidavit of support in these cases, before you go forward to naturalization, you just want to go through the analysis. Is there, you know, because he could be, you could get a great order. Well, and this would be something I think worth doing too, is that it might even be worth going and getting the order to enforce the affidavit of support, even if he can't pay it, because then you have that debt on the record. And then if in some point he comes into assets, she gets her money.
Mm-hmm.
I had a case once where something like that happened. It's like this big boatload of money showed up like 10 years later because he got some
it's a good retirement plan, right?
Yeah, something happened. So it's worth it as the family lawyer to get those judgments either way, but you have to do it before she naturalizes.
So a follow-up question on that is, are you still able, well, it's a little more technical in that, but are you still able to change the basis of the I-765 during USCIS interview? So the initial one was filed jointly, but now the client is eligible for battered spouse waiver.
So I'm going to answer this. I don't know it from the practice standpoint, but I'm going to answer it from what the USCIS FOIA told us, and then I'm going to turn it over to Edna and Veronica. What the FOIA said is actually USCIS has policies in place. This is where the one place where the battered spouse waiver policy, there's like policies directing the people doing the battered spouse waiver interviews, and the policies are set up for exactly this instance. They say if they discover the abuse during the interview, there's a process by which they essentially give the victim an opportunity to file their battered spouse waiver and to withdraw the joint petition request that was jointly filed. And there's a process, and the details of the step-by-step of that process that they go through at USCIS is in your training materials in the FOIA documents. But strategically, what happens? How does it really play out in real life, Edna and Veronica?
Well, I had only one case like that where he didn't show up, and we had enough evidence, right? The order of protection, the police report, all of those documents, and the officer gave us a request for more evidence at the interview, and then we submitted more things, and then he issued the green card without having to go back for an interview. But it was, you know, like he gave us, I think the maximum is like 87 days, right, to submit any more. He wouldn't take what we had with us, but he basically just said, this is what I need from you. And then he processed it without the interview.
Yeah, so I've generally amended prior to interview because we know in advance, even if I don't have the evidence all collected, you can send in something saying that you're amending the basis of the I-751 and that you'll be submitting additional evidence within whatever amount of time. If an interview is already set and it's coming up very quickly, I would still send in that amendment to give them a heads up and then come prepared with evidence, because I've had the same as Veronica, where I've had an officer just take it and be like, great, I'll review this and we'll go through the interview, I'll review this and I'll let you know. And then I've had others that say, you can't file it this way, you need to respond to an RFE. So I think that just kind of depends. But there was, I think, a change. I mean, there were years apart. So I think there was also a change in practice and in adjudications as well too. But you are able to amend it at the interview. There's no reason why you shouldn't be. But the more advanced notice you can give the adjudicating officers, the better, because they like that. They know what to prepare for. And then they might even like kick out your interview or just send you the RFE in advance. And it saves you and your client a trip out to USCIS that you might not have to make in the first place.
And one of the reasons it's a really good thing to do about doing in advance and letting them know is, I mean, this is going back to battered spouse waivers in the beginning, before VAWA. And that is that, you know, if you're going to have an interview, who's going to show up? It's the abuser and the victim. And there have been times where abusers will threaten the USCIS guys. And so you're actually doing them a favor, not only saving time, but giving them a heads up that this abusive person is going to potentially walk into their office. And actually what's interesting about that, I'm thinking about VAWA confidentiality, the moment you're also giving them notice that he's an abuser. So if they try to do an interview and rely on any information he's provided, they're barred from doing that by VAWA confidentiality. So you're setting up these giant red flag that keeps them from relying upon perpetrator provided information, because you don't know what the perpetrator might have told them, because it's his case to control.
And then the last question is asking about expedite. So is there a way to expedite the cases in your experiences?
There's a new expedite policy. It's available on the USCIS website. We can send it to you, after the webinar, but I don't have it pulled up right now. The problem is that it's not like sending an expedite request to the Vermont Service Center, where you have a trained group of people that deal with the abuse cases all the time, because they're scattered all over these district offices. And it's not my understanding that people have had much success with expedites on battered spouse waivers. What is your experience, Edna and Veronica?
No, I haven't. Our office hasn't at all. I don't know about you, Veronica.
I haven't requested an expedite. My clients are just happy that the green card has been extended, right? 18 months it used to be, and now they are issuing them for 24 months. And so, you know, I may be able to apply for citizenship before my client actually gets that removal of the condition. But due to the pandemic, I think they are just overwhelmed that they are extending the green cards for longer time.
So while the battered spouse waiver or Form I-751 is being adjudicated, the green card is automatically extended, and they have that in the form of a letter, or they can go to the CIS office and get a stamp in their passport, or how is it that you show that the green card is extended for practical reasons with their employer?
So they send you a letter with the extension, and the letter, the notice of action tells you that this paper is good for work and travel outside. Before, when they were doing biometrics, they would put a stamp, a little sticker in the back of the old green card with the extension date, and that was enough. But now that they are trying to prevent people from coming to biometrics because of COVID restrictions, they are just reusing biometrics that they have in their file, and they are just like refreshing them. And so then the only thing you're relying on is that paper. And I had one of my pending cases, the employer was asking, like, I need more than this paper, right, to do the I-9 for the employment. And I just send them, this is something that you are supposed to be accepting. And I just send them all the information, and then they process my client for his job.
Great, that's very helpful. Well, these were the last of the questions that were that we didn't answer live, and others that came up. If you have additional questions, you can submit them at info@newapp.org, or you can also email them to me. I've put you both options here again in the chat. And with that, to respect the time frame that we saved for you, I want to thank you all for joining us. And Leslie, Veronica, Edna, thank you for answering some of those questions. I feel really good that we were able to get to them and give everybody an opportunity to ask more if they had others.
Yeah, and I just put the new expedite criteria. First, I put the how to apply, but the criteria to expedite I put in the chat. So you might want to grab that before you leave. And it does include VAWA confidentiality violations now.
Okay. Well, I look forward to visiting with you guys again in December and having you join some of our other webinars. And thank you, Jenny at NCJFCJ, for hosting us, and look forward to talking to you next month.
And thank you, Edna and Veronica, for your expertise and joining us today. We really appreciate it. And we invite those of you that are family lawyers to join the family law community practice, or victim advocates to join the victim advocate community practice. And hopefully we'll see you all there. Thank you. Or at one of the many future webinars we're going to be offering. We have December 13th. We're going to be doing custody.
All right. Bye.
Thank you. Bye.
Bye.